General Studies Mains Mock Test 1049-2018. 1. Concerns regarding the wide formulation and indiscreet application of discretionary powers of the governor need closer attention. Discuss. Approach. Give a brief description of the discretionary powers of the governor as mentioned in the Indian Constitution. Highlight the issues and challenges posed by these powers with respect to Indian federal polity. Cite relevant case laws and reports. Conclude with suggestions. Answer. The governor has a great role in promoting cooperative federalism as he acts as a vital link between the center and the state government. In this capacity, he has certain discretionary powers as given in Article 163(1) and Article 163(2), according to which the governor will have the final say if any question arises about any matter falling into his discretionary powers. Thus, it seems to provide the governor with wide-ranging powers. Not just wide formulation but in discrete application of these powers he has also raised various concerns such as Article 200 and 201, the governor has the power to withhold the assent to a bill along with reserving the bill for the consideration of the president. States allege that this provision has often been misused by the governor who acts on behest of the union government. Article 213, the power to promulgate ordinances when the state legislature is not in session. This power has been misused through repromulgations without trying to pass the bill in the Assembly. Article 356, to recommend the imposition of constitutional emergency in a state. For political gains, this power has been abused by central governments more than 120 times till date. Article 164, appointment of chief minister. In case of a hung assembly, the governor has discretion to invite a party to form government has often been questioned. The most recent examples being Go and Manipur elections. Governor is charged with duty to preserve, protect and defend the Constitution. However, governors often perform their functions as agents of the center. To limit the discretion of governor, the Supreme Court in the case of S.R. Bob v. Union of India held that such exercise of control of the Union executive over the state executive is opposed to the basic scheme of the Indian Constitution. Sarkaria Commission report also stated that even the limited area of choice of action should not be arbitrary. It must be a choice debated by reason, activated by good faith and tempered by caution. It should be a right of a citizen to seek remedy through a court of law if the governor fails to defend the Constitution. In this context, the Supreme Court, through cases such as Shams Singh v. State of Punjab, have set aside the absolute immunity that may be claimed by an office of the governor. 2. Explain the concept of subordinate legislation in India. Also discuss the mechanisms for their scrutiny and control. Approach. Briefly explain subordinate legislation in India. Discuss the criticisms of subordinate legislation and the need of scrutiny. Conclude with suggestions. The governor has a great role in promoting cooperative federalism as he acts as a vital link THGOVER, nor has a GRESROLDINDROMBOTING BELIFM as he accord S as a VITLL. Discuss mechanisms of scrutiny and control. Parliamentary scrutiny debate. Question hour. Motions and committees, judicial interpretation and public consultation. Conclude with the need to reconcile subordinate legislation with parliamentary primacy in lawmaking. Answer. Subordinate legislation is a process by which the executive is given powers by primary legislation to make laws in order to implement and administer the requirements of that primary legislation. Such law is the law made by a person or body other than the legislature but with the legislature's authority. Article 13(3) of the Indian Constitution includes within the definition of law forms of subordinate legislation such as order, rule, regulation, notification. The need for subordinate legislation arises due to limited time available for legislation implemented due to overburdening, increasing complexity requiring knowledge and experience of experts. Covering those situations which have not been anticipated by the Parliament. Flexibility in meeting emergency situations. However, the concept of subordinate legislation faces criticisms on many grounds, including undermining separation of power, legislation by unelected people, lack of publicity, etc. Thus, there are various mechanisms for scrutiny and control of delegated legislation. For example, Parliamentary scrutiny and control. It occurs at various levels such as during the debate on the Act, the relevant departmental standing committee may recommend the scope of delegated legislation. Statutory motion to discuss rules. After the rules have been tabled, MPs may move a statutory motion seeking an annulment or modification of the rules. Question hour. Committee on Subordinate Legislation. Both the houses have a standing committee on subordinate legislation to oversee whether the power delegated by Parliament to the government is being properly exercised. Every delegated legislation needs to be laid before the Parliament within a stipulated time frame. Public consultation. Some acts mandatorily require prior publication and consultation on draft rules, while in others the government may exercise its discretion and invite comments on the draft rule. Judicial scrutiny and control. Delegated legislation may be declared invalid on the grounds of violation of the Constitution of the India or the violation of the Enabling Act. There has been an exponential rise in delegated legislation in India. Thus, apart from strengthening the existing mechanisms, a separate law like the Statutory Instruments Act of the UK, providing for uniform rules of laying and publication, may be looked into. The committees of Parliament may be supplemented by a specialized body to make vigilance of delegated legislation more effective and reconciled with democratic principles of parliamentary control. 3. The crucial position accorded to the Speaker in Indian legislatures makes it imperative to protect them from undue political pressures and incentives. Examine. Approach, introduced by highlighting the position of the Speaker in Indian legislature. Discuss the instances in our polity where the Speaker of the Assembly has precipitated a political crisis by seemingly political decisions. Discuss the provisions and measures that can help to protect the Speaker from undue political pressures and incentives. Conclude on the basis of above points. Separation of power, legislation by unelected people, lack of publicity, etc. Southeast Hard. Answer. The office of the Speaker occupies a pivotal position in our parliamentary democracy. The Speaker is looked upon as the true guardian of the traditions of parliamentary democracy. The crucial position of Speaker can be understood from the following points. The Speaker of the Lok Sabha conducts the business in-house, and decides whether a bill is a money bill or not. They maintain discipline and decorum in the House and can punish the members for their unruly behavior by suspending them. They also permit the moving of various kinds of motions and resolutions, such as a motion of no confidence, motion of adjournment, motion of censure, and calling detention notice as per the rules. The power to disqualify an MP or an LA under anti-defection law lies with the presiding officer of houses and assemblies. In view of these, there are many safeguards in the Constitution, such as security of tenure, salaries charged on Consolidated Fund of India, discussing their conduct only on substantive motion, etc., to protect the office of Speaker from undue political pressure. Though the Constitution envisages the Speaker as a neutral position, but there have been numerous instances in our polity where the action of Speaker has raised concerns. For example, 16 MLAs from the ruling party in the Arunachal Pradesh Assembly and 9 MLAs in Uttarakhand Assembly were disqualified by the Speaker in 2016 despite not officially leading the party or defying its directives, etc. Controversies regarding declaration of Aadhaar Bill 2016 as money bill by the Speaker. Thus, more steps are required in addition to the existing safeguards. For instance, power to decide upon the question of disqualification can be entrusted to Election Commission of India. After getting elected as Speaker, he/she must resign from the party membership as practiced in mature democracies like UK. Also, his constituency should go uncontested in the next general election. Democratic conventions must be evolved through political consensus in order to ensure non-partisan actions by Speaker. 4. The departmentally related standing committees have been referred to as mini-parliaments in India. Highlight their relevance in the democratic polity and discuss, with examples, how they improve the overall effectiveness of the Parliament. Approach. Start your answer with brief introduction about departmentally related standing committees. Write about their relevance and contribution in democratic process. Conclude your answer with few shortcomings and suggestion to improve their efficiency. Answer. The full-fledged system of 24 departmentally related standing committees (DRSC) covers under their jurisdiction all the ministries/departments of the Government of India. It is a path-breaking endeavor of the parliamentary surveillance over administration. Relevance in the democratic polity. Parliament as a whole can't go into details of each bill or grant due to its huge size and paucity of time. This is facilitated by the RSCs. They perform legislative role consisting of parliamentarians, hence called mini-parliaments. Imparts legitimacy to Indian democracy as the functionaries of committee are elected representatives, effective in obtaining public feedback and building political consensus on contentious issues. Instances in our polity where the action of speaker has raised concerns. For example, has important functions like CONSIDERATIO and demands for grants, examination of bills referred to by the chairman, Rajya Sabha or the speaker, Lok Sabha, consideration of annual reports, consideration of national basic long-term policy documents presented to the House and referred to it, improving overall effectiveness, function throughout the year and in a way so as to compensate for parliamentary time crunch. It makes parliamentary control over executive much more detailed, close, continuous, in-depth and comprehensive. Usually involves experts while scrutinizing bills. Devoid of any political positioning/populist opinion. Mandatory scrutiny of bills by committees ensures better planning of legislative business. For example, the DRSC on Commerce provided useful insights for ease of doing business. Each DRSC focuses on a set of ministries and, therefore, helps its members build sector knowledge. However, DRSCs don't have dedicated subject-wise research support. Also, there are issues relating to the transparency committees meet behind closed doors and only the final report is published. Important Constitution Amendment Bill to enable the GST was passed by Lok Sabha without reference to the DRSC. It is important to further strengthen the ability of DRSCs to undertake detailed scrutiny of legislative issues. Reforms would inter alia include mandatory examination of all bills, creating research teams, and improving the transparency of input/evidence/submissions to the DRSCs. 5. Enumerate the issues associated with functioning of tribunals in India. How can these be addressed? Approach: give a brief introduction about tribunals. Enumerate issues associated with functioning of tribunals. Mention solutions to address the issues. Answer: tribunals were originally set up to provide specialized and speedy delivery of justice to reduce the burden of caseloads on regular courts. However, the functioning of tribunals has been suboptimal due to the following reasons: lack judicial independence. Appointments to tribunals by the executive is non-transparent. Their funds and 10 functionaries are regulated by the executive, thus undermining judicial independence. Many e-tribunals often act as extended office of concerned departments, manned by officials rather than judicial members. Access to justice. As tribunal benches are located at few locations, it possesses inherent difficulty for many litigants. Infrastructure, inadequate workforce and infrastructure, lack of information available on the functioning of tribunals due to unresponsive websites. No uniform recruitment, conditions for service, retirement age. This puts tribunals at the mercy of the parent ministries. Congestion in higher judiciary due to litigations against the decisions of these tribunals. Judicial overreach by tribunals. For example, Armed Forces Tribunal granted non-functional upgrade to Armed Forces, which is objected because it does not have the power to pass such an order. Directives by NGV in the domain of policy making is another example. Over-tribunalization. Existence of numerous tribunals with varied and overlapping jurisdictions. Sidestepping high courts, as in some cases, an appeal against the order of an appellate tribunal can directly be filed in the Supreme Court. The above-mentioned issues could be addressed through the tribunals, which replace the jurisdiction of the courts should enjoy the same constitutional protections as higher courts. Daily include mandatory examination of all bills, creating research teams, need for a new tribunal's service to address the questions of membership and staffing of tribunals. The location of benches of certain tribunals must be driven by empirical studies. The extent of tribunalization that is permissible under our Constitution should adhere to SC ruling in the Draft Bar Association v. Union of India. ensuring administrative and institutional autonomy to Tribunals. Law Commission has also provided a blueprint regarding appointment, qualification, selection and tenure of members as well as location of tribunals which should be implemented at was the earliest. 6. Examine the significance of Gram Sabha, as mentioned in Article 243A of the Indian Constitution, in the development process with special reference to 5th Schedule areas. Approach. Briefly describe Gram Sabha and discuss their significance in developmental process. Discuss significance of the Gram Sabha for 5th Schedule areas. Answer. Article 243 of the Indian Constitution defines the Gram Sabha as a body of persons registered in the electoral rolls relating to a village within the area of the Panchayat at village level. As per Article 243, a Gram Sabha may exercise such powers and perform such functions at the village level as the legislature of a state may, by law, provide. The Gram Sabha is the cornerstone of the entire scheme of democratic decentralization in India. Its significance in the developmental process lies in the following: every adult of the village directly becomes a stakeholder in development process. Discussing the report on socio-economic development programs implemented by the Gram Panchayat GP. Examining the annual statement of the accounts and audit report and the annual report of administration of the Gram Panchayat. Identification of beneficiaries of various anti-poverty and rural development programs. Mobilization of voluntary labor and conducting community welfare programs. Activities associated with development programs like land acquisition or changes in forest rights need consent of Gram Sabha. In reference to the 5th Schedule areas, the Gram Sabha has been vested with wide-ranging powers under Panchayat Extension to Scheduled Areas Act, 1996 to safeguard and preserve traditions and customs of the people and their cultural identity. Community resources. Customary mode of dispute resolution. These powers include ownership of minor forest produces, mandatory consultation during land acquisition, management of minor water bodies and control over mineral leases for minor minerals, prevent alienation of scheduled tribes and also work to restore unlawfully alienated lands, controlling the business of money lending to scheduled tribes, issue a certificate of utilization of funds by the Panchayat for the plans, programs and projects. Gram Sabhas have been very crucial in Schedule B areas in creating awareness about traditional and cultural rights of tribals and in prevention of illegal mining, deforestation and encroachments. This has been demonstrated by cases like rejection of the Vedanta mining project in the interest of the Nilgiri tribe. However, states have been circumventing the authority of Gram Sabhas by diluting the provisions of 5th Schedule and PSA through laws and regulations to promote ease of doing business and attracting investments. This does not augur well for grassroots democracy and inclusive development, and states must be more sensitive to concerns of local folks and work towards empowering Gram Sabhas. Legislature of a state may, by law, provide. The Gram Sabha is the cornerstone of the entire scheme of